The Honorable Supreme Court of the State of Illinois.
Mr. Marshall, the Supreme Court is reconvened.
Oyez, 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 the Supreme Court is reconvened.
Before I start calling the first case this morning, on behalf of my colleagues and myself, I would like to thank you for your adaptability and cooperation in participating in our remote oral arguments this morning. Thank you very much. First case on the call of the docket is agenda number 5, case number 125091, People of the State of Illinois versus Joseph A. Hollahan appellee. Mr. Millar, you may begin.
Thank you, Your Honor. May it please the court, opposing counsel. I am Nick Muller for the appellant, People of the State of Illinois. The case at hand regards about 15 minutes. 15 minutes in which no one spoke to the jury except the trial court instructing them about what was about to happen. They were allowed to rewatch a video they had asked to rewatch, and then they were allowed to return to the jury room and continue their deliberations. No one spoke to the jury. The jury did not speak to anyone else, and no influence was brought on the jury. Now, there are 2 ways to characterize those 15 minutes. The first the people believe is the correct characterization, that deliberations were paused under the discretion of the trial court during the viewing of the video, and then they resumed when the jury returned to the privacy and the secrecy of the jury room. The second characterization is that the jury deliberations continued throughout and there was no pause. However, the people believe the first characterization is the better judgment of what occurred. The trial court has discretionary power to suspend jury deliberations and does so regularly. It does so at the end of the night if the jury has not come to a verdict and it needs to be sent home. It does so if the jury needs to be brought back into the courtroom for instructions or answers to their questions. It may even do so if a juror needs to use the facilities and the other jury must stop deliberating until that juror comes back. Now, the defendant agrees in his brief that the trial court has its discretion to order this type of suspension. And if that is what we are characterizing those 15 minutes as, the analysis pretty much ends there. Because whether or not the court erred in ordering that suspension, that type of error would not rise to the level of second-pronged plain error. And that's because if jury deliberations are suspended, there can be no intrusion upon those deliberations. The secrecy and the privacy are not violated because the deliberations simply aren't happening. Now, in that instance, the constitutional issues and harms raised by defendant are not at issue. There are no constitutional issues for that type of error. And because of that, it does not raise to the level of grave and serious error or impinge upon the integrity of the court in the way required to find that second-pronged error occurred. However, if this court chooses to characterize those 15 minutes as a continuation of deliberations, if they were not a suspension, defendant still cannot show that plain error occurred. And that's because the first thing defendant must show is that a clear and obvious error did occur. Now, defendant argued that the people have forfeited the argument that a clear, obvious error had occurred. And I'd just like to state first briefly that because you cannot have a second-pronged plain error analysis without first asking whether an error occurred at all, the question of clear and obvious error is a part of second-pronged plain error. It's the same issue, and therefore it was not forfeited because it was not focused upon in the people's PLA. And even if it is not a part of that same question, it's so inextricably linked that it should not be deemed forfeited. Now, defendant cannot show clear and obvious error in this case because this court and the United States Supreme Court have both made clear that in order to show an intrusion upon the jury occurred, a defendant, especially in the plain error context, has to show that prejudice occurred. It is not enough to say that prejudice might have occurred. You have to show from something on the record that something influenced the jury. That simply did not happen in this case because no one spoke to the jury. The jury did not speak to anyone. No one overheard any deliberations. There's been no showing of prejudice, and this court made clear in McLaurin. And the United States Supreme Court made even clearer in Alano, which dealt with non-jurors in the jury room, that that is not sufficient to show an error occurred. The United States Supreme Court directly addressed the question that the appellate court below found relevant of whether there is a chilling effect, and noted that yes, there could be a showing of prejudice through the chilling effect, but that chilling effect cannot be shown merely through the presence of non-jurors. And that's all defendant has to go on in this case, because no one said anything to the jurors. Both parties were there, so it can't be said that there was a bias one way or the other felt by the jury. And because of that, the fact that they were allowed to go back to the jury room, nothing occurred. The record is silent on anything that could have been influential or prejudicial.
Mr. Molar,
Yes.
couldn't all of this been avoided if the judge had excused the parties in the courtroom to another courtroom, to another room, so the jurors could be by themselves?
Your Honor, in that case, I do believe it would be an easier, more straightforward question of the fact that then the jury has just been moved to a different type of jury room, even though in that case it's a courtroom. But it's important to note that the reason it's hard to tell whether what the trial court did in this case was the best practice that trial court could have done is because the record is silent on what the court's rationale was. The court is silent about any objections defendant might have had. And the reason we don't have that record is because defendant never objected. Defendant didn't give the court the chance to explain itself or to reconsider its position. And when a defendant doesn't object, the plain error doctrine has been brought into being because defendant still has an opportunity to claim errors, but it has to be recognized that if defendant doesn't object in the first place, if it doesn't allow the record or the trial court to explain itself, then the defendant can't then rely on the fact that the record doesn't show the necessary information because it's his fault. He didn't object. And so that is why—
May I ask you a question?
Yes,
Counsel. This was a retrial, right? This
Yes.
case had been tried once and there was a mistrial declared. And so this was the second time of the trial. Does the record tell us what was the basis of the mistrial?
Yes, Your Honor. In the first, there were similar circumstances in the first trial where the jury again for the first time wished to see the video again. However, in that first trial, I believe the video was on a VHS tape and there was not the technology to cut out certain inadmissible portions. And what happened was I believe it was the prosecutor was unable to stop the playing of the VHS tape in time, and non-admitted portions of that tape were viewed by the jury, and that's what led to the mistrial.
So in the first case, something went amiss with the technology, and therefore there had to be a mistrial and a retrial.
Yes.
And so in the very same situation where the jury asked to see the tape again, in this case, the court fashioned a remedy that allowed everyone, the judge, the attorneys, as well as the jury, to observe exactly what took place in front of the jury. Is that what happened?
I believe so, Your Honor, but I want to make clear, just so it's clear, it was not the same tape in the second place. By that time, they had, I believe, burned the video onto a DVD and removed the objectionable portions. However, the people believe, while that first error from the first trial was no longer possible because the tape had been changed, I think it goes to the court's state of mind, the fact that these type of errors exist, and shows why it's not clear error that the trial court acknowledging that maybe this should be done where people can see it, since we don't have the technology set up, so that if something wrong does occur, it either happens on the record or both parties are there so that they can preserve their interest if that needs to happen. In this case, nothing happened. The jury watched in silence and went back to the jury room. No one
Mr. Moeller,
Yes,
Mr. Moeller, is it your position that because of the judge stopped jury deliberations, there was no error at all?
Your Honor, I believe that is the people's position, that the stopping of deliberations was within the trial court's discretion. And then even if the trial court made the wrong decision in stopping jury deliberations, that type of error is separate from an intrusion upon the jury, because if deliberations have been stopped, the constitutional issues that underlie intrusions upon the jury don't apply, and it becomes much more just a mundane error in the sense of clerical duties or administrative duties of the court. So if it is a suspension of jury deliberations, then error or not, it cannot be second pronged plain error. However, even if it wasn't a suspension, if jury deliberations continue throughout, because there has to be a showing of prejudice to show clear and obvious error occurred, and defendant cannot do so, there was no clear and obvious error. And I think that follows fairly straightly under Hollahan, which had a similar situation in which non-jurors were allowed into the jury room. But that analysis also has to reflect on the next question of, even if there had been error, is that second prong plain error? And logically, it cannot be. This court has said second prong plain error is for those errors that are so serious, that so infect the integrity of the court, that prejudice has to be presumed. However, this court has already said that for the type of error alleged here, for intrusions upon the jury and their deliberations, there will not be a presumption of prejudice. So it can't follow then that we say you have to show prejudice, but you also, this is so serious, you don't have to show prejudice. The two analyses would contradict each other, and therefore it just can't be second prong plain error, because this court, though in a slightly different context, has already said, no, you have to show prejudice for this type of error. That aside, just taking it from a blank slate, this is not the type of error that second prong plain error is. Second prong plain error is meant for the most serious and gravest instances of error in the court. Here, the jury was allowed to watch a video in silence for 12 minutes, with the extra minutes coming in the instruction and the leaving. There's nothing that shows any sort of prejudice. There's no reason to believe anything grave or fundamentally wrong occurred. And because of that, it's not second prong plain error. Now, for the first time in this court, defendant has also raised an argument that this would fall under the first prong of plain error, which is the closely balanced test. That simply isn't the case. This was not a closely balanced case. Defendant, it was testified by a police officer that defendant was driving in a fashion that violated traffic laws. When he stopped, he was brought out of the car. He smelled of alcoholic beverage. He admitted he had had several beers, and then he was unable to pass one. He failed all three of the sobriety test administered by the police officer. The trial court then allowed the admission of the video, which is at issue in this case. That video shows the sobriety tests occurring largely as the officer said they did, although we cannot see the same types of failures that the officer testified to with things like the gaze test, because the camera's too far away and we don't have the necessary training to gauge that. It is clear that defendant is having trouble balancing in that video. And the most reasonable inference from it was this man, who's admitted to 4 beers, is under the influence of alcohol such that it impedes his ability to drive. Now, the only evidence against that was defendant's testimony, in which he said, well, yes, I was at a bar for an hour or I was at the bar for a couple of hours and then I went driving, but I wasn't impaired. This goes against the evidence. It goes against the fact that he refused to take a blood alcohol test, which can be used as evidence of guilt. And so looking at the evidence, the state had a strong case. The evidence was not closely balanced, and first prong plain error would not apply, particularly where here, the error being claimed of still shows no effect. Whether the evidence was close or not, there's no reason to believe that the watching of a video in the presence of others and then being allowed to deliberate in complete privacy and secrecy after that had any causal effect to prejudice defendant in some way. So unless there are any further questions.
Any questions?
I apologize, Your Honor. The people would ask that this court reverse the judgment of the appellate court and affirm the judgment of the trial court. Thank you.
Thank you, Mr. Hollahan. Mr. Santiago Durango, please, your turn.
Good morning, Your Honors. Counsel, my name is Santiago Durango with the Office of the State Appellate Defender, and I represent the defendant appellee, Joseph Hollahan, in this matter. May it please the court. Your Honors, the state's argument is remarkable. The state is arguing that a jury can be ordered to review, a deliberating jury can be ordered to review the key evidence in a case in silence without being able to, in the case of a recording, as in this case, to stop the recording, to rewind the recording, to confer about what they are viewing or hearing. The state argues that this is not an intrusion or an infringement of the jury's right to deliberate openly without fear of having their deliberation influenced by outside sources.
Mr. Durango, is it your position that the court did not suspend jury deliberations, that this was a continuing process of deliberations while the tape was being viewed?
I do, Your Honor. Simply put, evidence was being examined. It was being examined under supervision, but still being examined in the deliberation. So there was a continuing deliberation. This is not a situation where, for example, the jury was on a break and there was no examination of evidence happening. This is a situation where the jury was examining evidence, but in a supervised fashion. So there was deliberation.
It is not your position, is it, that the jury deliberations cannot be suspended?
No, there are situations where the jury deliberations can be suspended, but those situations did not occur in this case. So, for example, the court has discretion to supervise deliberations when there's a concern that the evidence will be overemphasized, or that the evidence will be viewed out of context, or that there are matters in the evidence, in the recording in this case, that should not be considered. If the court is concerned that the defendant will be prejudiced without the court supervising the examination, or if there's a concern that the evidence may be damaged or destroyed. None of these factors were present in this case, so there was no need for the court to supervise the examination. If there had been recording equipment in the jury room, the jury would have been able to examine this recording without interference in the jury room. The mere fact that it had to do so in the courtroom did not in and of itself justify the supervision in this case.
Was the judge required to allow jury to review this tape again in the jury room or anyplace else?
That is our position, Your Honor, that the jury, because of the cardinal principle that the jury that the defendant has a right to have the jury review the evidence in private and secret. The method that is least intrusive should have been chosen by the court in order to give meaning to that principle. In this case, it would have been easy for the court to simply close the courtroom and there would have been no problem.
So would it have been error for the judge to refuse to allow them to see the tape because they couldn't do it in the jury room?
No, the court does have discretion to prohibit review of the evidence. But once it does allow review of the evidence should be allowed to be reviewed in the same manner as any other evidence. Now, recordings should be, in general, be reviewed and treated as any other type of evidence that a jury reviews. So there was no reason in this case for the intrusion into the review of the videotape, although the court could have disallowed the review. Once it allowed the review, then it must have allowed the review to occur the same as with any other evidence that the jury could have reviewed in the jury room.
Counsel, may I inquire, back in the day when I did trials, jury trials, and before a lot of technology, it was not uncommon to have jurors request that the court reporter read back testimony that had been given. Is that error to allow the court reporter to read back testimony to the jury in the circumstances we have here? Is that structural error?
Again, that depends on the circumstances. In this case, the supervision was structural error or second prong error, because the intrusion rendered the deliberations an unreliable means of determining the guilt or innocence of the defendant. We're speaking of the key piece of evidence in this case. There were three main pieces of evidence in the case. One was the inculpatory evidence of the trooper who effected the stop. Two was the exculpatory evidence of the defendant. And three, the objective videotape of the stop. In closing argument, both parties repeatedly referenced the videotape, and defense counsel called it the most important piece of evidence in the case. And this also goes to the closeness of the evidence, because obviously you have conflicting versions of what happened, and you have the one piece of evidence that objectively shows what happened. And the problem here is that the jury was not allowed to discuss, to stop, to replay this key piece of evidence during its deliberation. It was chilled by the court's instructions that it remained silent. There was no method provided for stopping or reviewing the tape. I cited a Seventh Circuit case in my brief where the Seventh Circuit noted that with recordings, an audio recording in that case, a conscientious jury might need to stop, rewind, discuss different portions of the tape in order to carry out its duty. In this case, the jury, in reviewing the key piece of evidence in the case, was not allowed to do that. And again,
how does this case comport with our decision, our court's decision in McLaurin?
Well, McLaurin, if I recall correctly, the facts were different in this case, because in this case, there's a clear showing that the deliberations were chilled. It's not simply the presence of silent alternates. In Olano, the presence of the silent alternate was characterized by the court as being similar to having an open book in the jury room. There was no interference at all from the passive jurors. In this case, however, there was a chilling effect that prejudiced the defendant because the jury was instructed to remain silent, and there was no ability for the jury to stop and rewind and discuss the tape, the key piece of evidence again, while it was deliberating.
If you agree, though, that it would not have been error for the trial judge not to even allow the tape to be replayed, how can it be error to tell the juries to watch it in silence. I think the judge did say, or if there's anything else you need to do, which might indicate they could have asked for it to be stopped or rewound other than having them do it themselves. I'm not sure I understand why it was error to allow the jury to view the tape again when it would not have been error to refuse to allow.
Well, let me suggest this illustration. Let's say that the judge, in the exercise of her discretion, she of course would have had the right to the discretion to not allow the viewing of the videotape. But if she, let's suppose that she would have allowed it and it could have been watched in the jury room. At that point, we would not have the problem that we have right now. Again, I go back to my argument that once the judge allowed the evidence to be considered, the evidence, unless we have one of the factors that are used to authorize and justify supervision, which are not present here, once we eliminate those factors from the picture, then there is no reason for the judge to supervise the viewing of the tape. Just because it had to be viewed in the courtroom does not by itself justify the supervision in the case.
So may I ask you this question? Of course, at this proceeding, there was no objection. Defense counsel never presented an alternative, what would work better, never asked the court to make a fuller record. Everyone seemed to agree with the judge's approach here in the moment. So what is our standard of review?
Abuse of discretion. So the court's ruling was not reasonable, precisely because if it caused an interference with the jury's ability to deliberate that was not necessary. The court could have simply closed the courtroom and the jury would have been able to deliberate and we would not have this problem.
Mr. Durango?
Yes.
With regard to the others present in the courtroom, it was the defendant and his counsel and also the state, right? They were all viewed in the courtroom at the same time?
Yes, in addition to
So would any other occasion permit those people to be, it's one thing about the judge supervising, but it's another thing having all these others present during the deliberations that were not suspended. Is that the problem?
That is the problem, Your Honor, that is part of the problem, that there were other persons there. And the other part of the problem is that the jury was ordered not to speak during the deliberation and was not given any means for stopping or rewinding the videotape. One way to see that error occurred here is to imagine if this had happened with the ability to view the videotape in the jury room. Would it have been error for the court to walk into the jury room with the parties, the court reporter, and the alternates, and order the jury to remain silent while viewing the videotape? That would have been clear error. And it would have been error that would have been substantial and second prong, and I would argue structural error. So clearly what happened in this case, if it would happen in the jury room, would have been error.
Counsel, even if there was no showing of prejudice whatsoever, that would be clear structural error if that happened?
Yes, Your Honor, because the problem is that having, let's say this would have happened in the jury room, the fact that the jury was not able to freely deliberate in privacy and in secrecy would have affected the reliability of the decision-making process.
Counsel, Alano happened in the jury room. I mean, you know, in this case, we're not talking about best practices. The Rouse case, in the Rouse case, the first district said that this may not be the best practice, but the issue is prejudice. And what you seem to be arguing is that this procedure here, without any actual prejudice, because my understanding is nobody said anything or did anything in the trial court while this video was being played to show that there was, to prejudice the defendant. But you're arguing basically this is inherently prejudicial. And I thought that argument was shot down in Alano.
No, Your Honor, Olano actually supports the position that what occurred in this case was prejudicial, because Olano pointed out that when the jury is chilled in its deliberations, prejudice occurs. And what we have in this case is a situation where the jury was chilled because the jury was asked to not deliberate and discuss the evidence that it was viewing. And in this case, it was the key evidence that it was reviewing. So again, imagine if this would have occurred in the jury room, that there clearly would have been a chilling of the deliberations. And from that flows the prejudice.
Alano, of course, said respondents have made no specific showing that the alternate jurors in this case either participated in the jury's deliberations or chilled deliberation by the regular jury. So clearly in Alano, the alternates were there during the deliberations. Is your entire argument then premised on the thesis that deliberations were not suspended here, that the jurors were deliberating while they were in the courtroom?
Right, they were deliberating while they were in the courtroom. Another way to give perspective to my argument, one of the cases I cited was the Bennett case from the Ninth Circuit, where there was an exhibit, a propeller that was just too big to bring into the jury room. So the jury had to examine the propeller in the courtroom. The fact that the jury had to examine the propeller in the courtroom did not mean that the deliberations were suspended. In that case, the courtroom was closed so that they could in fact have frank deliberations in private. That should have been done in this case. So the fact that deliberations have to be conducted in the courtroom from time to time does not mean there's no deliberations. Deliberations can be held in the courtroom, and many cases have stated that deliberations can be held in a closed courtroom. And the fact that evidence was being examined shows that deliberations were occurring. If no evidence was being examined, then there is no deliberation. But when evidence is being examined, of course, it follows that some form of deliberation is occurring.
Mr. Durango, to follow up on Justice Carmier's earlier question, the judge, I looked it up, the judge said specifically, if you need to have the sound adjusted or anything that we can do, all right. And that was the end of her comment after she told him she was going to play the video. Does that phrase or anything that we can do, is that not an open-ended invitation to the jury that, I mean, they didn't have the remote in their hand to play it back and forth, but was that an invitation to, you need to have it replayed? I mean, she didn't use those precise words.
Yes, Your Honor. Let's assume that it was an invitation to allow the jury to pause or to ask for a rewind. That doesn't solve the problem in this case, the main problem, which is that the jury could not discuss what they were seeing as they were watching the tape. Again, this was the key piece of evidence in this case. It involved a traffic stop where allegations of—
Mr. Durango, your time.
Yeah.
Would you like to
Well,
finish up?
Yes,
Would you
thank
like-
you, Your Honor. Given that there was no justification for the intrusion in this case, and the fact that the intrusion in this case rendered the deliberations an unreliable means of determining guilt or innocence, the defendant asked this court to affirm the well-reasoned opinion of the appellate court. Thank you, Your Honors.
Thank you. Mr. Millar, your rebuttal, please.
Thank you, Your Honor. Now, I'm a little bit confused about defendant's argument over whether this was a suspension or not, because he stated that in some cases, this type of procedure can be used. If the video could have objectionable material, of course, you could bring the jury back into the courtroom. You'd have the parties there. They would watch and they would go back in. Presumably, the jury is not going to be allowed to discuss the evidence in that instance, because once they do, then you are running into issues of shown prejudice on the record because the jury has been overheard. So in that instance, they're not allowed to talk, but defendant thinks the court has the discretion to order that. So the question becomes, yes, the deliberations were suspended. Was it right or wrong to order that suspension? And you still don't get into these questions of were deliberations intruded upon because they were suspended. It's just a question of whether that was an abuse of the court's discretion or not. And that's not second prong error.
Counsel, your opponent maintains that the jurors were chilled because they could not deliberate while they were in the courtroom. Explain to me why he's wrong.
Well, Your Honor, I think first it involves a misreading of Hollahan. Because yes, Hollahan does understand that chilling can take place. They specifically mention it could have taken place with non-jurors, the alternates, in the presence of the jury. But the Supreme Court said that's not something you're going to presume, though. You have to show that chilling effect taking place. And that's not here. Here, all we have is the presence of the parties. That's no different in any substantive way from the presence of the alternate parties in Hollahan. The question of chilling effect still has to be shown. And on this record, there is no showing of that. And the idea that the jury was chilled is somewhat undercut by the fact that they were allowed to fully converse before and after the video was shown. The trial court did not have to show them the video. It had the discretion to say, no, you cannot see it. It had the discretion to say, you can see it, but only once. And it's important to point out that the facts in this case, that's not what happened. The trial court said, we could have the sound adjusted or anything that we can do, all right? Now that, to me, the most reasonable reading of that is to say, if you need it stopped, if you like it replayed, that's anything we can do. However, what it most certainly is not is a direct statement that those things could not occur. So even taking that statement by the court that they could do anything in the best light for defendant, that's still not an affirmative statement that you can't rewatch it, that you can't stop it. And the fact is we're in plain error review, which means the presumptions do not go in defendant's favor. The fact that the court did not affirmatively say or say anything suggesting that the jury could not rewatch the video, that has to cut against defendant. And defendant spent a lot of times on the actual circumstances of this case, the facts that made it right or wrong for the court to decide to suspend deliberations and bring them back into the courtroom. And I just want to point out that those types of considerations are not second prong plain error considerations. If this case lives and dies on the specific facts of it, that's not the consideration you take into effect when you're talking about second prong plain error. Second prong plain error are those grave, serious, integral errors that go across all cases. So if this court, like the court below, is making a rule about second prong error, it's not the specific instances, it's the type of error at issue. And so we don't need to look at these specific facts. It's just this question of, is the jury not being allowed to speak, watching the video one more time in the exact same circumstances it did during the trial? Is that an integral error among the worst errors that can occur in the judicial court system? And it's just not. So unless there are any further questions. The people would ask again that you reverse the judgment of the appellate court and affirm the judgment of the circuit court. Thank you.
Thank you, Mr. Millar. Case number 5, number 125091, people of the state of Illinois versus Joseph Hollahan, as agenda number 5 will be taken under advisement. And I thank you, counsel, Mr. Millar and Mr. Durango, for your arguments this morning. Thank you.